If you hold a U.S. green card and travel internationally, there are important changes coming that you need to understand. Starting in 2026, how returning residents are evaluated at U.S. airports will shift in a meaningful way, and that shift can affect whether re-entry is smooth or involves extra review. This is based on confirmed guidance from the Department of Homeland Security, not online speculation. Here's the key idea up front. Lawful permanent residents are not losing the right to travel. What is changing is how officials assess whether the United States is truly your primary home. Under the updated enforcement approach, officers may pause re-entry if they believe a person's long-term travel patterns suggest they no longer primarily live in the U.S., even if no laws were intentionally broken. Picture a common scenario. You return from what felt like a routine trip. Your documents are scanned, there's a short delay, and you're directed to speak with an officer again. In that moment, familiar assumptions about re-entry can suddenly feel uncertain. By the end of this video, you'll understand why that situation can happen, who may face closer review, and what practical steps can help reduce risk as the new framework rolls out. Before diving deeper, let's acknowledge something important. A green card represents more than permission to live and work in the United States. For many people, it reflects years of effort, family separation, financial cost, and long waits. So, hearing about stricter re-entry review naturally creates concern. That reaction is understandable. However, this is not a moment for panic. It's a moment for clarity and preparation. The updated rules do not ban travel. They signal that travel is now evaluated with more structure and less flexibility than in the past. Outcomes depend less on any single trip and more on long-term patterns, documentation, and timing. Once you understand how border officers are expected to apply these standards in 2026, you can move from uncertainty to informed decision-making. My name is Sofia, and I focus on following U.S. immigration policy updates and how they are applied in real-world travel situations. I want to be direct and precise here. Reports about changes to green card re-entry are grounded in official DHS and Customs and Border Protection guidance. This updated enforcement framework is scheduled to phase in beginning in early 2026 and applies to lawful permanent residents who travel internationally. On paper, these changes may look procedural. In practice, they can feel very different, especially for people who are used to frequent or extended travel. Waiting until your next trip to understand the new approach increases the risk of surprises at the airport. Major news organizations have already reported on this guidance, but many residents haven't seen the details or don't realize how the rules work day to day. At the center of the update is one concept: residents' intent. Officers are being instructed to examine whether a returning resident's travel history supports the idea that the U.S. is their primary home. This assessment is becoming more data-driven and less discretionary than in the past. Previously, many travelers relied on informal benchmarks. Trips under a year were often fine. Longer absences could be explained with context like family obligations or temporary overseas work. Officer discretion played a significant role. That environment is changing. The new framework emphasizes patterns, timelines, and accumulated data rather than individual explanations. Frequent or extended time abroad may now trigger closer review as a potential indicator that permanent residence has shifted elsewhere. This is where misunderstandings often arise. The main concern isn't one long trip by itself. It's how your total time abroad compares to your time in the United States over a defined period. Past hassle-free travel does not automatically protect you going forward because each entry can involve a broader historical review. Here is an important threshold to understand. Under the updated approach, time spent outside the United States for more than 180 consecutive days, about 6 months, can result in automatic enhanced screening at re-entry. This is system-based, not dependent on conversation style or past outcomes. Enhanced screening typically means secondary inspection. In that setting, officers may review your full travel record and begin evaluating whether your actions align with someone whose life is primarily based in the U.S. Depending on the findings, further steps may follow, including requests for documentation or formal proceedings to assess status. It's also important to know that the 6-month mark is not the only factor. Even without a single long trip, residence may be reviewed based on cumulative travel. The updated model looks at total time inside versus outside the US over a rolling multi-year period, often around 3 years. If the data shows that less than roughly half of that time was spent in the United States, the system may flag the case for review. Short trips can add up, especially for people who travel often for family care, business, or shared living arrangements across countries. In simple terms, officers are no longer just asking, was a rule broken? They are asking, does this person's overall pattern show that the US is still their main home? And they are expected to apply that question conservatively. This means the burden has shifted. Being prepared to show continued residence matters more than ever. Let's look at how this can play out using two illustrative examples. Consider a resident named Maria. She lives and works full-time in the US, files US taxes, and maintains a home there. Over 3 years, she made several trips abroad to care for an aging parent, each lasting about 6 weeks. Altogether, she spent fewer days abroad than in the United States during that period. Under the new framework, Maria's travel would likely be reviewed, but her overall pattern, employment, housing, finances, and physical presence, supports ongoing U.S. residence. She might face questions, but her documentation and presence ratio work in her favor. Now compare that with Carlos. He also holds a green card and has lived in the U.S. for years, but he operates a business overseas and divides his time between two countries. Over 3 years, he spent more time abroad than in the United States, even though no single trip was especially long. Under the updated system, Carlos is more likely to be flagged for review. In secondary inspection, officers may ask him to demonstrate that the U.S. remains his primary home. At that point, intentions alone aren't enough. Documentation becomes critical. Without clear evidence, his status could be questioned at the port of entry. Both individuals traveled frequently. Neither intentionally violated immigration laws. The difference lies in the overall pattern their travel created. A common question is whether these changes mean green card holders should stop traveling altogether. The answer is no. Travel itself is not prohibited. What has changed is how travel is interpreted over time. Occasional trips, family visits, or even multiple journeys in a year can still be reasonable if your overall life remains centered in the U.S. Risk increases when extended or frequent travel leads to more time abroad than at home. Another frequent concern involves long stays abroad for legitimate reasons, such as caring for a seriously ill family member. Documented emergencies can still be relevant, but the emphasis is now on evidence. Records such as medical documents, employment letters, or official paperwork matter more than verbal explanations. Extended work abroad can be more complicated, particularly if it involves non-U.S. employers or businesses. In those cases, officers may interpret overseas economic activity as a sign that a person's primary base has shifted. Many people also ask about re-entry permits. These permits remain valid and can help preserve status during longer absences. However, under the updated framework, a re-entry permit does not guarantee uncomplicated entry. It reduces certain risks, but officers may still review overall residence patterns. The key takeaway is that relying on what worked in the past is no longer sufficient. The system is evolving, and future enforcement looks forward, not backward. So, what steps can help you prepare? First, calculate your presence ratio accurately. Review your passport stamps or travel records from the past few years. Count the total days spent inside and outside the United States. If your U.S. presence is close to or below half, that's a signal to proceed carefully. Second, organize documentation that shows your life is based in the U.S. This may include recent tax returns, proof of housing, employment records, U.S. bank statements, insurance, and evidence of close family ties. These materials should be current and accessible while traveling. Third, if you anticipate a long absence, consider applying for a re-entry permit well in advance. Processing can take time, so early planning matters. Fourth, if your situation is complex, frequent travel, mixed residence, extended overseas obligations, speaking with a qualified immigration attorney before traveling can be a proactive step. Professional guidance can help you assess risk and timing. Finally, adjust expectations. A history of smooth entries does not guarantee future outcomes. Current patterns and documentation are what matter most. I want to close with this perspective. These enforcement changes are not hidden traps, but they do place greater responsibility on travelers to be informed and prepared. Permanent residence today is something that must be actively maintained through presence, records, and planning. You still have time to review your situation and make thoughtful adjustments if needed. Understanding the rules now can help prevent stressful outcomes later. Everything discussed here is for general informational purposes only and should not be taken as legal advice. Immigration law and enforcement practices can change, and individual circumstances vary. If you have concerns about your specific travel history or plans, consult a qualified immigration attorney and verify details through official government sources. Thank you for spending this time with me. My goal is to help you understand the rules before they affect your life. Stay informed, stay prepared, and I'll see you in the next update.